SJC-09903, Commonwealth v. Leon Robinson.
Okay, Attorney Caddick, whenever you're ready.
Okay, may it please the court, Elizabeth Caddick for Leon Robinson. There were two main defenses in this case. One was mistaken identity, and one was the origin of the minuscule dot of blood on Mr. Robinson's jacket. Due to a number of errors by counsel, the court, and the district attorney, these defenses were all but defeated. First, the trial attorney committed ineffective assistance of counsel by not hiring a eyewitness ID expert. The second was the failure to admit the swatch of blood that the jury specifically asked for. And the third was the court's failure to give an honest but mistaken identification instruction.
Can I ask you about the swatch?
Yeah.
Because we have the chemist, I take it, testifies that, you know, I swabbed and I took out this little swatch and here's the jacket and there's a missing piece. And the failure was not to put the actual swatch
Right.
into evidence. But this testimony was 2 millimeters, and then there's a ruler that shows this tiny 2 millimeters. So how is that prejudicial, given the evidence that was properly before the jury?
Well, a couple of reasons. One is it was relevant to the jury. They asked for it. Sure. They asked if it was admitted, so they wanted to see it. They already had the ruler. They already heard the testimony.
But what are they going to do with a little tin that has a little tiny piece of fabric in it?
Well, for the same reason that the Commonwealth always wants to admit physical evidence, the defense should have wanted to admit physical evidence. It's very persuasive. It's more persuasive than a ruler and looking at the two little lines and trying to be able to...
And it's a jacket with a hole, essentially, in it.
Yeah, but the hole doesn't represent the spot of blood. So the relevance, of course, to the spot of blood was that even the Commonwealth's expert agreed that it was so small that it's hard for it to have been a blood spatter because it's so small it doesn't travel much of a distance. And she agreed that there can be transfer of blood and DNA through contact. And so the defense was that...
It was the handshake.
Yeah, and there was evidence that the third-party culprit defense was that it was the brother, and that there was evidence even from the brother that he met Mr. Robinson later that day and they may have shook hands. So that's one of the failures. And
which way does it cut not to introduce it? I mean, normally you're benefited by their failure to dot their I's and cross their T's, right?
Right,
so
but
why does this hurt you that they don't put this in?
Because the damage of the DNA testimony was already in. They had the forensic scientists state that the DNA was that of the victim. And so the defense was that the spot of blood was so small, it wasn't blood spatter, it wasn't put there at the time of the shooting. Mm-hmm. And so that's why it was important, because it was now an item of defense as opposed to...
Wasn't it clear from all the testimony and everything that it was a very tiny spot?
Right, but in my mind, I can't envision what 2 millimeters is.
That's why you need a ruler.
And but even a ruler, how often do you look at a ruler and you're trying to figure out whether you're looking at inches or centimeters and where's 1, where's 2? So no, it's the spot of blood. It's actually seeing that you can't see it. I mean, it hadn't been found apparently for a year and a half. It had been in the Commonwealth's possession for a year and a half. Someone eventually spotted it, and so that was necessary for the jury to see. And when the defense attorney knew that the jury came back with the question asking if it was admitted, knowing that the smallness of it, the minuscule size of it was what was exculpatory. He should have asked to reopen the evidence and admit it. Certainly, there could have been no harm because all the harm had already been done with the testimony by the forensic scientist.
Can I ask you a different question that you raised on the honest but mistaken
Yes.
instruction that was asked for and not
Yeah.
provided? Are you aware of any cases where we've said it should have been given, but the standard instruction where it says something to the effect of "you may consider the witness may simply be mistaken" is sufficient to excuse a failure to give an honest but mistaken instruction?
Well, I don't remember finding a case like that. I cited cases in the brief where the court, one was the appeals court, had stated that in that particular case, because there could have been an honest but mistaken identification, it was reversible error not to give it when it was requested.
Yeah, I guess
Yeah.
more I'm concerned about the context of the general instruction that does have some language, not maybe enough to your
Right.
liking, but it does have some language in it.
Right, but it simply stated that someone could have been mistaken, but the honest but mistaken instruction goes into it more and actually makes the witnesses seem more sympathetic and allows the jury to feel that these witnesses were trying to be honest, were trying to remember correctly, but they were just mistaken. And
Oh, you answer the question, it's the honest part of the honest but mistaken is what's missing.
right, exactly. And it talks about how they try to do their best, but people can be mistaken. Also, in this case, that was such a legitimate instruction because we had, which ties into the failure to get an eyewitness identification expert, we had the possibility of bystander misidentification where Mr. Robinson was in the barbershop getting his hair cut, continuing to socialize, and all the research that shows, and the research was available even before this 2005 trial, that people will misidentify an innocent bystander sometimes 3 times as much or sometimes 6 times as much as someone who instead of the actual culprit. Also, there was this change blindness, right? We found out at trial that one of the eyewitnesses said that Mr. Robinson left the barbershop and sometime later came back in. And so the argument by counsel, but he didn't have an expert for it, was that he could have just perceived, as the research on change blindness says, people expect continuity, so they saw him go out and they expected him to come back in.
The motion judge found that the expert could have cut both ways, given the well-lit area at the time, the fact that observations were made beforehand in a non-stressful environment, and the interactions between the parties, right? That cuts the other way on an expert.
Well, but if you still have bystander misidentification, they had a long time to look at the bystander, and then the change blindness, who they were describing was Robinson. I think one example.
This is a strategic decision, correct?
Well, he said, no, I disagree. He said it was. He said that it could cut both ways.
Defense attorney said it was, right?
Yes, but he spoke in general terms about, well, an expert could cut both ways. There's no evidence that he even...
I thought he said he made the tactical decision not to.
Yeah, but that doesn't, that's not the end of the evaluation, just because he says, oh, I did a fine job. I mean, it had to have been reasonable when made, and it would have been reasonable.
But it's our standard, though, right? Because we take ineffective assistance and even in murder cases on strategic decisions differently than we do other decisions.
That could be, but even a tactical decision, as I said, has to be reasonable when made. And had he hired an eyewitness ID expert, consulted with them, and then decided, oh, this is a double-edged sword, I'm not going to call him, then it would be much harder to argue against. But he didn't specify anything specific about why it would be difficult in this case. And what we have as some evidence of, change blindness, and is that the Rainey and McIntosh, the two eyewitnesses, and Rainey had only been in there about 20 minutes, they had testified that Leon Robinson walked with a limp. None of them had testified that, afterwards they saw the shooter walk with a limp. The only person who saw just the shooter was Dorinda Carter. She saw him walk out of the store, and she saw him walking along Commonwealth Avenue when she was turning around, and she said she paused for about 10 seconds as she was making a U-turn, and she saw the shooter walking. She was asked specifically, did he have a limp? She said no. So there's evidence to support not only the need for an eyewitness ID expert, but also for the honest but mistaken identification. And that went along with what the defense attorney was arguing in his closing argument, that they made a mistake, and they had the weapon, they were stressed, he left, he came back, and they misidentified him as being there just for the haircut. So by not having the instruction would have become the law of the case had the judge given it. By not giving the instruction, then the defense attorney was left with just making his own argument, which the judge told them is not evidence. So that's why the instruction was important. And so that was another way that one of his defenses was defeated. And there, I'd also like to get to the improper closing argument about motive. The defense, of course, was that it was Michael who was the shooter, and there was a substantial amount of evidence that the night before the shooting, Bobby Stevens had a fight with the victim, and he claimed the victim had choked him. He got very upset. He came into the store and he made a motion with his hand in his pocket as if he had a gun. Some people ran. He went to his cousin Michael and explained to Michael what the victim had done and said, I want to kill him. And Michael said to him, I'll take care of it. During his testimony, Bobby Stevens admitted to this. He admitted that he even said to Ricardo, the victim, I'm going to get someone to get you. And he said to the police, and by that I meant Michael. Then, later, the night before the murder, Bobby Stevens goes to these 3 Boston College students' house and rants about Ricardo and says he's going to kill him, and that his cousin Michael said he'd take care of it. So, and then the defense evidence was that Robinson met up with his brother Michael later that day, and Michael admitted on the stand they could have shaken hands. So that was a well-crafted third-party culprit defense, that it was Michael who was the shooter. Then, after all this, at closing argument, the Commonwealth said, well, Michael and Leon are brothers, so saying that only Michael has the motive and not Leon doesn't make sense. Aren't they both brothers? Doesn't Leon have the same motive? Well, there was no evidence that Leon had any motive. There was no evidence that he was at all involved or knew anything about the fight the evening before. And yet, what the end...
Did they live together, Leon and...
No.
Meg? Okay.
No, and there's the evidence of Michael lived right near there, and Leon lived in West Roxbury, not in Brighton. And the defense counsel objected to the argument, and the judge overruled it. So it gave the appearance, I mean, not only was there not a curative instruction, the jury was given the impression that it was a legitimate argument, and it was something that they could consider. And so, again, that was the additional way in which the defenses were defeated by these errors at trial. I would like to then, anyone have any questions about those arguments? Okay, I would like to talk about the denial of his motion to proceed pro se because of his desire to present a specific defense that his defense counsels did not. There were 2 hearings.
Did the colloquy take care of that?
No, the colloquy, no, because what the judge did is ask him.
Seemed like they struck a bargain.
No.
No?
I think if you carefully read it, they did not. What he did is after she said, I understand you know how difficult this will be. You're an intelligent person. I know you have some experience in the criminal law, although not a jury trial. And I know you understand what you're facing, but I'm not comfortable with you representing yourself because this is a first-degree murder case and you need the skill of a lawyer, or words to that effect. And so she then denied him his right to proceed pro se, and then he said, well, I understand, but I want to put on the record my objection that I want my defense presented. And then she said, clearly as a way to placate him, well, she didn't say you can then, after the defense rests, which, she said after the defense rests, if you want, you can come up to sidebar and you could put an objection on the record. She certainly didn't say, okay, I'm suspending my decision on this, let's go to trial, and if you don't like how it's going, then come up and remake your motion to proceed pro se, and I'll take it from there. That's not at all what she said. She was just telling him he could put his objection on the record during trial if he wanted. So that was very different. And so the defense attorneys were clear, stating multiple times.
Sorry, can I just ask, so did he take her up on that?
He did not, but the defense attorneys did. They took a sidebar when the DNA expert was about to testify and told the court, I am questioning this expert for our defense. I am not raising the defense my client wants, and he wants me to put on the record that this defense we're raising is over his objection. So it was put on the record during trial, but it was by defense counsel. So,
I'm
yes.
sorry, so the defendant didn't come up and say, here we are, this is the issue that I wanted to deal with?
No, but there's no way he could have presented no way he could have presented his case.
Was he unambiguous in his quest to be pro se?
Yes, and it's because the defense attorneys came in, particularly on March 10th, 2005, in that hearing, and said, we've had hours and hours of discussion with him. We are at an impasse. We are not going to raise his defense. And he said he would rather go pro se. And throughout that hearing, they said he wants to go pro se. And that is legitimate. I've cited, case law that says that a lawyer can speak for the client, particularly when the client is right there. And so there was never...
The quote I have is, Your Honor, I understand it'll be a tremendous task. I'm not as good with the law as it might seem. I'm not. I'm willing to go along with counsel with their theory and not to go pro se on this.
Right. Are you quoting from the Commonwealth's brief? Because the defendant then goes on to say, but I want my defense presented. I mean, he was willing to have the defense. It was the defense attorneys who said, we can't do both. We can't say...
I'm quoting from the record.
Oh, okay. Well, I thought it was right. When I looked at what the Commonwealth quoted, and I went to the record, he said, but I still want my defense presented. He was willing to have both the defense
Right,
attorney.
but it seems like he wants his cake and eat it. He says, I don't want to go pro se, but I want it my way.
Well, what he's saying is, I know it's difficult to go pro se, but if I have to, if that's the only way I can get my defense presented, then that's what I want. I agree he's
I mean,
inarticulate.
we'll look at the
but-
record carefully to
Right.
see whether or not he unambiguously said he wanted to go pro se
Well,
and it was denied.
He did unambiguously say he wanted to go pro se. I think the
I'm sorry, I
most
didn't-
the common
he did not?
the most the Commonwealth could argue is that he conceded that the lawyers could raise their defense and his defense. Initially, he was, I don't want their defenses blaming my brother. I don't like that. And I want mine. And he eventually said, okay, they can raise their defense, but I want my defense raised too.
Right.
If there are no further questions, thank you.
Okay, Attorney McLean.
Good afternoon. May it please the court. Ian McLean on behalf of the Commonwealth. I'd like to acknowledge the presence of two members of the victim Ricardo Robinson's family with us in the gallery here today, as well as several of Mr. Robinson's family members watching the live stream. Your Honors, I'd like to start with the Guardado issue briefly before I turn to the argument specifically raised by.
Is there any case law that says that if, because a post-conviction case takes 18 years, there's a waiver?
Not the number 18 years, Your Honor, but Beauchamp from this court in 1997, the test as it was articulated then was where a defendant by his own fault fails to take a direct appeal in a timely fashion. So the timely fashion
In
is
that
not
case,
been...
he was a runner, right?
Correct, Your Honor. He fled and was ultimately apprehended in California. He picked up federal charges, had to
A little
serve that
different
time.
than this.
I'm sorry, Your Honor?
A little different than this. We
Well,
don't have
this-
someone running. We have,
This is on direct appeal.
Yes, it is, 18 years after his conviction.
Right, no, I mean,
And, Your Honor, I think that the point there is that if the defendant, by his own fault, however it occurred, by his own fault, drags out the case, as he did here, essentially dragging this appeal to a halt, it taking 18 years, he's not due the benefit of changes in the law that happened there. So that timely fashion that they referred to in Beauchamp, not defined. But this court, a few years ago, established the standing order to track first-degree murder cases and said 18 months as the time period. I'm not suggesting every case is actually going to make it in that standing order time period, but double it or even triple it.
this is the firearm conviction, right?
I'm sorry, Your Honor?
We're dealing with the firearm conviction in this case.
Yes, Your Honor. Yes, Your Honor. But I mean,
Let me ask you about the murder conviction.
sure.
On the honest but mistaken, I take your brief and it says that the judge said you may consider whether the witness simply may be mistaken. That was in the standard instruction. And the judge denied the honest but mistaken instruction. Are there cases that, to your knowledge, that say that that language suffices to satisfy an instance where an honest but mistaken should be given?
Well, Your Honor, I think the Presley case acknowledged the Rodriguez standard instruction doesn't include that extra bit that the judge gave here, but didn't provide any mandated language. So to my knowledge, there are no cases that provide the actual mandated language to cover honest but mistaken.
So your knowledge is honest but mistaken is not mandated.
That's my understanding, Your Honor. And it's not covered in the standard Rodriguez, but what was given here was not the specific requested instruction by the defendant, but this was the additional language tacked on to the end of the Rodriguez charge.
your opposing counsel references an appeals court decision which reverses when it's not given. What is your reaction to that?
DeVrosio, they refused to give it. It's my understanding is that there's not any case law that mandates it being given, but they outright refused to give it, and there they determined, yes, it should have been given there. There's not a
But
blanket.
that case doesn't have the tack on that
Correct,
the
Your Honor.
judge did in this case.
Correct, Your Honor. That's what was refused. In addition to the Rodriguez, the tack-on was refused. So here the tack-on is, in analyzing identification testimony, you may consider whether or not the witness might simply be mistaken. From my perspective, from the Commonwealth's perspective, that covers the honest but mistaken portion of the charge. And I'd point the court to Fawn, as we all know, we read instructions as...
Okay, I'm getting lost. And so that would wipe out the need to ever give the honest but mistaken instruction then. If mistake is enough, then all our cases about this honest but mistaken it's all gratuitous. That doesn't make sense, does it?
Well, Your Honor, I'd point out that this trial happened back in 2005. So the judge at the time didn't have the benefit of any cases that have happened since then. What the judge gave.
Again, and unlike Justice Gaziano, I wasn't doing this in 2005, at least regularly. I'm confused, though. 2005, wasn't the honest but mistaken instruction in play at that time?
From my understanding,
And that's
no.
a question, not an answer.
From my understanding, no, Your Honor. Rodriguez was sometime in the 80s, I believe, and then Presley was the case that acknowledged that the possibility of an honest but mistaken instruction.
And that's what year?
83. And there was no actual language given in Presley as to like mandated language to use to communicate an honest but mistaken identification.
So when do we start regularly giving the honest but mistaken instruction?
I'm not sure, Your Honor, but it was after 2005.
So it's after this case, it becomes sort of a regular occurrence.
Yeah, so the point is not the magic language that were used, but the language the judge used at the time, did that adequately communicate the concept? And here, I think when you...
But your opposing counsel does a good job of saying, honest but mistaken gives a jury a different take on things than mistaken. It's more sympathetic to...
Well, Your Honor...
Or more receptive to, hey, person can be doing the best they can, but they've just got it wrong. And it's not just it's possible for having a mistake, but it's more helpful, or it wouldn't be de rigueur, right?
Well, Your Honor, I think if you read the tack on to the Rodriguez instruction that was given here at 854 that we're talking about, and then you read that in conjunction with the instructions on 813, and those instructions are you have to determine which witnesses to believe and how much weight to give their testimony. Also, in addition to finding the facts, you also have to assess the credibility of the witnesses. So I think when you read those three things together, it covers both that they're blatantly lying to you about their identification or that they believe it but they're incorrect. And
That's correct. Then the honest but mistaken
Did you give
instructions.
I'm sorry, did
Go
you
ahead,
give
go
the
ahead.
instruction that said you can believe some of what a witness says and all of it? Or parts of what they say?
I don't remember that specific phrasing came in, but you have to determine which witnesses to believe and how much weight to give their testimony. In addition, you have to also assess the credibility of the witnesses. That means the believability of the witness. So to me, that means you could believe part, all, some, none. So they were given that instruction. And as we said, there's no magic language, and we have to read the instructions as a whole under FAN. So while they didn't specifically use that word, honest but mistaken, I think that was adequately communicated through the combination of all the instructions that were given here. So I would then turn from there to the claims of ineffective assistance of counsel, beginning with the swatch.
Before you, just to
Yes, Your Honor.
deal, because I'm more bothered by this issue than others. So when we go through the case law out there, we're not going to find cases where the decision not to give this honest but mistaken language was reversible error. Are we going to find that?
I don't believe so, Your Honor. In and of itself, DeFrozio, the case the defendant cited, is the case that
That's
gets
the
closest.
only one? Yeah.
That gets closest. But there was no additional language to the standard Rodriguez given at all. Nothing additional.
Okay.
So turning to the ineffective assistance claims, first regarding the swatch of the jacket, Attorney Boudreau in his affidavit at Defense Exhibit 129, or Defense Appendix 129, acknowledged that this was not an error, it was a tactical decision. He didn't want to put in the Commonwealth's evidence. So because it was a tactical decision, we look at whether it was manifestly unreasonable. So what did he know at the time he made that decision? He knew that the jacket itself was in evidence, Exhibit 38. He knew that there was testimony about the stain on the sleeve. There was testimony about the size of the stain, that it was 2 millimeters. There was testimony about the cutting from the jacket. Again, the jacket itself being in evidence. He knew that a ruler had come in so that the jurors could measure the size of the stain. And he knew about the testimony about the testing of the stain on the jacket and the DNA results. The two arguments that he wanted to make as a result of the blood on the jacket was they were not impacted by the absence of the swatch itself. And the swatch itself was merely cumulative of all of the other pieces of evidence that came in. So when you're analyzing the question of whether it was a rational decision for him at the time to not try to reopen evidence and then put the swatch in, it was cumulative of all of the other evidence, and it didn't prohibit him or prevent him from making the two arguments he wanted to make about the
What
blood.
about the argument of opposing counsel that the jury was specifically interested in the swatch? They had asked a question.
Well,
How does that factor into the reasonableness of this tactical decision?
I don't think it changes the analysis at all. If you look at the marked document, which is Record Appendix 120, what the handwritten question said was, we would like to see the videotape. So that's what they're concerned about, something entirely unrelated. And was the leather swatch part of the evidence? That's all that they asked. So I don't think that affects the situation at all. And what Attorney Boudreaux said is, regardless of whether it was at the time during the trial or at the time when the question came, his response is, why would I put the government's evidence in? Why would I help the Commonwealth with their case? So was that decision manifestly unreasonable or not? And it wasn't, because the ability to make the arguments that he wanted to make from that piece of evidence still existed. And he made those arguments during his close.
Speaking of the closing, was it fair game for the Commonwealth to say that, well, they're brothers, so they had the same motive?
Yes, Your Honor. Yes, Your Honor. It absolutely was. The defense, look at the defense closing argument. The very first thing that he says is, who has the motive? And then 3 pages later, volume 8 at page 123, he says, Michael Robinson had the motive. So that's a fair response when the prosecution stands up to respond to that argument that was made.
But is it speculative that he just because they're brothers, that he would have the same motive?
Not necessarily, Your Honor. So Bobby Stevens, the person that had the fight with the victim, came and reported to Michael, the defendant's brother, that he had this fight, was furious with him. Then the testimony that did happen, Justice Kafker, they didn't live together, but the brother did testify that he saw the defendant, Leon Robinson, every single day. So from there, you can draw the inference that what was communicated to Michael Robinson from Bobby about the fight that he had was then communicated from Michael to his brother, Leon, the defendant in the case. So it's an inference, but it's a fair inference based on evidence that came in, and it is a response which is completely appropriate to the closing argument from the defense counsel that led with who has the motive.
Did the defendant request to go pro se?
No, Your Honor. He waffled and oscillated and prevaricated back and forth, and that doesn't meet the standard.
Which one?
All three, which he's basically still doing now. So the right to counsel is automatic. The right to represent yourself, to proceed pro se, has to be invoked unequivocally. And the reasoning for that is so that we don't have this exact situation where a defendant comes up and prevaricates and waffles and goes back and forth, as this defendant did. So this case is categorically different. This case is categorically different from Barbosa, where the defendant unequivocally said, I want to proceed pro se, I'll represent myself, and I'll proceed pro se. Here, if you read the transcript of the ex parte hearing on the 10th of May, he said several things that I agree with the theory that they have at this point, was one of the statements he made. I probably wouldn't have any problems with counsel's theory, with their first theory. I really don't have no problem with it, Your Honor. And also, I'm willing to go along with counsel with their theory and not go pro se on this. That is the exact opposite of unequivocally invoking your right to represent yourself. And I'd also remind the court, as the Supreme Court has reminded us in Brewer v. Williams, that courts must indulge every reasonable presumption against waiver of the right to counsel. So here, where there's waffling, where there's going back and forth, it doesn't meet that unequivocal standard. So he did not invoke the right to represent himself. Excuse me, from there, unless there's somewhere in particular the court would like to go, I'd address the Brady claim that was raised. So what we're talking about here, just as a brief reminder, was during a pretrial interview, a witness, McIntosh, indicated that the defendant actually stepped from the doorway outside of the barbershop for a moment before he stepped back in, and the lecture continued, and then the gun was drawn. And that detail about stepping out wasn't captured in his pretrial statements that were produced in discovery. So the defendant claims that that constituted a Brady violation, and respectfully, it's not even close to a Brady violation. Brady violation requires three things. One, that it was in the prosecution's care, custody, or control. We acknowledge that. We were aware of it. Two, that it's actually exculpatory. This is not exculpatory. It's an innocuous detail. And then three, that the defendant suffered prejudice from it, which he didn't here. By comparison or contrasting, I'd look at the Vaughn case, where the new or the undisclosed information completely undermined the defense theory and arguably placed the defendant at the scene. This is not anything like that. 4 different witnesses placed the defendant at the scene. And the particular witness that we're talking about here, McIntosh, indicated that the victim and the defendant were in a discussion in the doorway of the barbershop. At some point during that discussion, the defendant stepped outside of the barbershop onto the sidewalk. Then he returned back into the barbershop. That discussion, that lecture from the victim, then continued. Not there was a new conversation, continued. That is a statement that it's the same person that stepped out, stepped back in, and the conversation continued. Then the defendant drew the gun and shot the victim in the abdomen. So this detail that he stepped outside of the doorway for a moment before stepping back in is an innocuous detail. It's nothing like the details that we're seeing in Pope. It's nothing like the details that we're seeing in Rodriguez Nieves, where the defendant was unable to effectively cross-examine the witness because the new detail, he needed expert assistance to be able to address that new detail. Similar kind of situation in Vaughn. This is categorically unlike those situations. There was no Brady violation here. This additional innocuous bit of information was not exculpatory. There was no failure to disclose exculpatory information here. Addressing the search warrant, unless there's a different place the court would like to go.
Can I take you back? I'm just looking at the honest but mistaken. I've got Commonwealth versus Presley from 1983, which is an SJC case. The defendant asked the judge to repeat the jury instructions and tell fair. But we're talking about, and then the case ends with the failure to give the honest but mistaken instruction was prejudicial, and we reversed there. So that's a 1983 SJC case.
Yes, Your Honor.
Saying you've got to give it or we're going to reverse. So it's not just this lonely appeals court rescript, but we got a SJC case right on point here.
Presley's the case, Your Honor, that acknowledged that the Rodriguez instruction doesn't contain an honest but mistake of fact component to it. That's what Presley says.
But we were also reversed because they didn't give the honest but mistaken instruction.
Because there was nothing additional that was given.
They didn't give any mistake there?
No, Your Honor, they gave this. My understanding is that Presley is the standard Rodriguez charge, which doesn't contain any additional information
Has
about.
nothing about mistake the standard Rodriguez charge?
No, Your Honor, that's what Presley was explaining and held right there, that there has to be some additional instruction given, but we're not going to tell you what exact language has to be given, but some additional language. And here there was additional language given, just not the exact language that the defendant asked to have given. So the question is, under Fan then, looking at the charge as a whole, did the judge adequately convey that concept? And respectfully, he did, when you combine the additional that he gave on 54, volume 854, with the components of the charge that came on pages 12 and 13 of volume 8. So turning to the search warrant claim that there was a lack of nexus, respectfully, the affidavit had all that was needed to establish a nexus to the defendant's residence. The affidavit established the defendant was the shooter. Multiple people identified him. Multiple known named people in the affidavit identified him as the shooter. The affidavit established that the residence, the apartment 53, was his. He admitted that after he was Mirandized. They confirmed it with the Boston Housing Authority. Then the question is, how do we get to these items are within the apartment itself? What we have is him being taken into custody 6 hours after the murder occurred, wearing a jacket consistent with the descriptions that were provided by multiple witnesses at the scene. But the clothing he's wearing underneath the jacket, not consistent. And he was taken into custody at a convenience store right outside of his apartment complex after the meeting was arranged through conversations with his mother. So what we have is him wearing one item of clothing, but not the other items of clothing when he's arrested. Taken into custody near his apartment a few hours after the murder. It's an entirely reasonable inference that he went home, changed his clothes, and those clothes are still in the apartment. It's also reasonable that the gun, an item of durable good of continuing utility, would also be in the residence. Even if you were unwilling to accept that inference, saying that it may have inherently incriminating value, so it wouldn't be in the residence, the other factor you have to consider is his opportunity to get rid of it. Would he have had enough time to get rid of it in that 6-hour window? Not necessarily. He was still in the same area. Then the third thing is the ammunition. Absent a prior conviction, which there isn't anything about in the affidavit, ammunition itself would not automatically be incriminating. So that argument that maybe he wouldn't keep a gun in the residence because of its inherently incriminating nature doesn't apply to ammunition. And the search warrant was seeking the clothing that he was wearing that they had a description for, the firearm and ammunition. There was an adequate nexus to the residence. It was a valid search warrant. The last claim that we haven't really touched on yet was the motion to view the file. This court actually denied that motion on a recommendation from the special master. The defendant was seeking access, unfettered access to the district attorney's file. That motion was properly denied for the reasons this court stated in its order. It wasn't tethered to a pending motion for a new trial. A motion to view the district attorney's file is a motion for post-conviction discovery. And under 30C4, any motion for post-conviction discovery has to be tethered to a pending motion for new trial with a specific claim. And that's what prevents the fishing expedition, because it's tethered with a prima facie showing to a specific claim and an explanation as to what this thing is and how it's going to support that claim. Here, all of those precursors or requirements were absent. So this court properly denied that motion to view the file. I think we've covered all of the issues, unless there are further questions.